Court does call the case of Affinity Investments and Technology versus Willie Cater.
This opening might sound routine, but what's unfolding here is a high-risk eviction situation already heading toward collapse. This isn't a fresh case. This is a continuation, which means the court has already given time, already heard arguments, and already expected compliance. And when a case returns like this, the tolerance level drops significantly. You've got a landlord trying to reclaim property while covering their own financial obligations, and a tenant who is now under pressure to prove reliability, not just intent. That distinction matters. Courts don't operate on promises, they operate on outcomes. And the moment you hear phrases like prior judgment and payment issues, you already know this is not just about rent, it's about failure to meet court-ordered conditions. That's where things become serious. What makes this even more intense is that eviction cases move fast once enforcement begins. There's no long runway left. Every statement now carries weight because the judge is evaluating one thing. Can this situation realistically be fixed right now? And as this unfolds, watch closely because this is where many cases shift from negotiation to final decision.
Good morning, Your Honor. Ron Ruark for the plaintiff, Affinity.
Good morning, Your Honor. Willie Cater.
We on this case.
Your Honor, we were here 2 weeks ago. At that point, I think it was the 15th or so, Mr. Cater indicated he had deposited a check. He did deposit that check, but it bounced. On the original possession judgment, he still owes $4,780. There's an additional $6,300 owed for April, May, and June rent. He owes over $11,000. I'm asking the court to reinstate the order of eviction with an effective date today so that my client can reclaim this property and pay their mortgage.
Peter, anything you want to say? Mr. Cater?
He's muted, Your Honor.
Can you hear me, Your Honor?
I can hear you now.
All right. First of all, good morning, Your Honor. And what Mr. Ruark said is partially true. I deposit the $5,000. Well, it was two payments that got deposited. I deposited $2,100 in money orders, and then my sister had wrote me a check for $38.80, and I didn't even know that the check didn't come back until Wednesday, until I talked to Miss Linda, which is my landlord, who texted me Wednesday morning and did on the 28th and told me that the check had came back. Didn't know anything about it. Immediately called my sister, asked what was going on. She said she'll call and see, Your Honor. I don't know what's going on with that, but I did deposit $2,100 and money orders that I got from Walmart, and my sister had wrote me that $3,880 something. I thought everything was all good until I got the text message early Wednesday morning, which was on the 28th, 2 days ago, and told me that it had came back. And I responded to her and told her.
Now we're about 2 minutes into the case, and the core issue is fully exposed, the bounced check. And this is where things get legally dangerous for the defendant. He's explaining that he didn't know the check bounced until recently. That may sound reasonable on a human level, but in court, that argument carries very little weight. Why? Because once you submit payment to satisfy a legal obligation, you are responsible for ensuring that payment clears. There's also a deeper issue here. He relied on a third-party check from his sister. That introduces uncertainty, and legally, that uncertainty becomes his burden. The court doesn't track who wrote the check. It only tracks whether the payment succeeded. Now here's the strategic problem. While he's explaining timing and communication issues, the plaintiff's argument is already focused on non-payment and accumulated debt. That's a much stronger legal position. So at this stage, the judge isn't just listening to explanations. He's measuring reliability. And once reliability is questioned in an eviction case, everything starts leaning toward enforcement.
Well, I don't know how much my check is this week, but I found out my check is $1,256. I did not know this check came back. I've been trying to keep up with these payments. On this single father, I work every day. I pay him every week. And it's just unfortunate that I'm not going to say it's my sister's fault. It's just unfortunate that it did come back, which I thought I was good, because the money that I'm supposed to deposit, I'm going to deposit tomorrow, I'd have been all caught up. But $3,880 of that, Your Honor, had came back. Other than that, I'd have been on point, Your Honor. So on the original, what Mr. Warwick talking about, the numbers are wrong with him, because I do the numbers well. And I've talked to the client. She's the one I've been to communicate with. So none of this, what he's talking about, never came up to me. Only thing she asked me to do from here on out, she said, and her exact words were, "It never happened to you. It never happened to you before." So just from now on, just put a cashier's check, a money order in there. And
Well,
that's
sir,
all.
sir, you were supposed to tender to them the $6,800 that didn't get tendered.
Yes, sir.
To them.
Yes, sir. I mean,
So
it got partially tendered to him, which, Your Honor, I'm a hard worker, single father.
I
You understand what I'm saying? I'm a hard worker, single father, Your Honor.
Mr. Cater, I don't
Yes,
doubt,
sir.
I don't doubt any of that. But at some point,
Yes,
the
sir.
funds have to be there. It's got to be paid.
And
This is the defining moment of the case. The judge cuts through everything: emotion, explanation, circumstances, and reduces it to one rule: the money must be there. That statement is not just a comment, it's a legal standard. Courts require actual, verified payment. Not expected income, not future checks, not intentions. And what the defendant is trying to argue is timing. He could have fixed it, he just didn't know in time. But the judge is making it clear that timing has already been accounted for. The court gave a window. That window has now closed. This is where many people misunderstand eviction law. It's not about whether you eventually can pay. It's about whether you complied within the court's timeline. And once that timeline is missed, the judge's role shifts from helping resolve the issue to enforcing the order. At this point, the outcome is no longer about negotiation. It's about consequences.
Your Honor, listen to me. I wish I would have knew. I had a 2-day notice of this, that it came back. Like, I could have deposited my check last week and this one and caught the $3,880. You know, I didn't know that this check didn't come back until 2 days ago. And you know, when you hear something like that, it's like, wow, when you think you know, it's like you've been defeated, because it's like I'm going forward, I'm getting caught up. But dang, I'm bouncing back now. Like, you know, I've never had no problem with Mr. Ward or my client like this. But, you know, I make good money, Your Honor. I pay them every week.
Then maybe you can work something out with them regarding this writ. But in terms of your motion to set aside the judgment, the motion to set aside is denied. The writ may issue.
Your Honor, should I submit a new writ?
All right,
Yes, sir.
Can I
I'll
ask you?
submit a new writ, Your Honor. Thank you very much.
I would like to know how much time is this new, or Your Honor, or how much do I have to pay to stop this writ? Is it the $3,880 that has to get in there? Because that's all.
Mr. K.
No, I only owe $3,880, Your Honor. Yes, sir.
I'm gonna wait for you to stop interrupting. Are you done?
Yes, sir.
Counsel, you indicated there's about 4,000 something on the judgment, correct?
4,780, Your Honor.
Okay. That's the amount.
That number is wrong, Your Honor. That number is wrong, Your Honor. It is. Oh, yes. I'm sorry. That number is right. And how much is owed on it, Your Honor, again?
Counsel, give him the number again.
$4,780 is owed on the original possession judgment. There's, of course,
all right. Thank you. Thank you so much for that. $4,080. Okay, Your Honor. And I just want to ask you so I can get an understanding.
Court calls the case of Abil Aguilar or Guiar Aguilar versus Michelle Dart.
Man, that's why you got to bring that.
Good morning.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
All right, where are we on this? I had last time the balance was going to be paid.
Your Honor, so it looks like the defendant did pay $1,450 of the $1,677.52 that was owed, which leaves a balance owed of $227.52.
Now we transition into a new case, and immediately you can see the contrast. The structure is similar, partial payment, remaining balance, but the scale is completely different. Here, the remaining amount is relatively small, and that changes how the court approaches the situation. When the balance is manageable, judges are more willing to consider conditional solutions rather than immediate enforcement. And that's exactly what's happening. The attorney suggests a conditional dismissal, which means the case can be closed if the payment clears successfully. This is essentially a controlled second chance. But unlike the previous case, this one comes with tighter oversight. The court isn't trusting blindly, it's setting a condition that must be verified. So the question becomes, is this a reliable payment? Or are we about to see the same issue repeat? Because courts don't just look at the present, they consider the risk of future failure.
All right. And Ms. Dart, what do you have to say to that?
Your Honor, I was paid today, and I went to 7-Eleven this morning, and I paid next month's rent and the $200 fee, making a total of $860.
All right, counsel, you don't have that one, correct? You don't.
I don't, Your Honor, and what I'm happy to do is if the court would allow, we do a conditional dismissal. As long as that payment goes through, the case will remain dismissed.
Ma'am, will that work for you?
Yep.
Okay. So what we will do is we'll do a conditional dismissal of this case, and I'll indicate order to follow. Ma'am, once that conditional dismissal comes in and you signed it, you'll have 3 business days to think about that conditional order. If for any reason you believe that there's some right you haven't asserted or some confusion on your part, you would have to file a motion within those 3 business days before this court. You understand that, ma'am?
Yep.
Okay, very good. I'll await
Am I to
the
be
order.
that form that I need to sign, or is that going to be through my landlord? Or I guess, is that through the court system? Or
Counsel,
my,
how do you intend on getting it to her?
We'll contact the landlord and get it to her through the landlord.
okay, that's all I
All
need
right.
to know.
Thanks, Judge.
Court calls the case, Andre Gilbert versus Marcus Hollis.
Good morning, Your Honor.
Your name?
Andre Gilbert.
Sorry, Mr.
All right.
Gilbert. Dan Shemke appearing on behalf of the plaintiff, Judge.
All right. Marcus Hollis? Is he here?
Yes, sir.
Oh, there he is. Okay, got it. All right. Where are we on this, folks?
Judge, last time around, you determined that we had filed the wrong complaint.
Yes.
Now we're a few minutes further in, and this case introduces a different type of issue. Not payment failure, but procedural error. Filing the wrong complaint might sound minor, but legally, it's significant. Every case must be filed under the correct legal grounds. If it's not, the entire case can be delayed or even dismissed. What the plaintiff did here is correct the mistake, refile properly, serve the defendant again, and bring the case back to court. That shows procedural compliance, which courts take seriously. Now here's the key detail. The defendant has made no payments since then. That strengthens the plaintiff's position significantly. So even though the case started with an error, it's now been corrected, and the focus returns to the same core issue, non-payment. This is how legal strategy works. Mistakes can be fixed, but once fixed, the court moves forward as if the case is now properly aligned.
We refiled a complaint for non-payment of rent, served it on the defendant. You had also ordered us to produce the ledger. That was
Yes, sir.
that was attached to the complaint together with another copy of the lease. And all of that went to the defendant, and now we're back here asking for entry of a judgment, which I just realized we had not submitted to you.
Yes,
So
that is correct. All right.
I propose,
And go ahead.
we haven't received any payments from the defendant, so I propose to move forward on entry of the judgment,
All right.
which will
Mr.
follow.
Anything you want to say on this?
Yeah, I'm gonna be making a payment real soon. That'll cover the whole thing.
The whole thing?
Yes, sir.
When you say real soon, when is that?
I would say in the next 2.5 weeks, I should be all the way caught up.
Okay, well, all right. Well, that's not going to quite work because then you're going to have July. You're going to pay that too?
Here's another critical moment. The defendant says he'll be caught up in 2.5 weeks. And the judge immediately rejects that timeline. This is a classic mismatch between personal expectation and legal reality. The defendant is thinking in terms of future recovery, when he can pay, but the judge is thinking in terms of current obligation, what is owed right now. And here's the key legal issue. Rent doesn't pause while you catch up. New charges continue to accumulate, so even if he pays past due amounts, he'll still fall behind again. That's why the judge says it won't quite work. It's not just about paying, it's about staying current. This is where eviction cases often become mathematically impossible for tenants to recover from without immediate full payment.
I'll probably still owe July, but I'll be caught up.
All right. Well, here's what I'm going to do. This is probably your advantage, actually. I'm going to grant judgment to the plaintiff for possession. What is your total amount that's owed, including costs, sir?
You asking me or my client, Judge?
I'm asking either of you, whoever can tell me.
All right, I can tell you there is, as of today, $3,950 in rent due, plus an additional $199.96 in unpaid utility charges, for a total amount today of $4,149.96. Of course, tomorrow there will be an additional $1,800 added to that amount, for a total, by the time I send my judgment into you and you enter it, the total, unless he pays in full today, will be $5,949.96.
Well, I'm entering the judgment today. That's what you wanted me to do. So I'm only going to go on what's due today.
And here comes the enforcement decision. The judge chooses to enter judgment immediately based on the current amount, not future projections. That's important. Courts don't speculate on what might be owed tomorrow. They rule on what is owed today. Now notice how the judge calculates a redemption amount, a specific figure that can stop the eviction if paid within a set time frame. This is one of the last protections available to a tenant, but it comes with strict conditions. The full amount must be paid. No partial payments, no delays, no negotiation. This is essentially the court saying, here is your final opportunity. Meet it exactly or the process continues.
So judgment to the plaintiff, redemption amount $41.49.96 with a writ to issue in 10 days. Court finding no tribal issue.
I have a question, sir.
Thank you. Yes.
Thank you very much, Judge.
What's your question, Mr. Hollins?
I was never served any papers with no amount, and that amount is still off, and that's not the real amount.
What do you mean you were never served any papers?
I was never served any papers, no papers were ever brought to me between the last court date and now. I have nothing regarding anything.
Judge,
Any other papers
questions?
were brought straight to me and were served directly to me, and nothing was served to me, sir.
Judge, those papers were served by mail, Mr. Hollis having appeared at the last hearing.
Yes. Okay. All right. Thank you.
Judge,
Mutual Rose Community Management versus Shirley Ramsey. This is the one, right?
Yes, and they are on it. You can see them.
She can see him.
Yes.
Okay.
Good morning again, Carrie Zanin, P67390 on behalf of plaintiff standing in for counsel of record.
Ms. Ramsey, can you unmute and then state your name? Okay, we can send somebody in there. Just hold on a moment, Ms. Ramsey. We're sending somebody in to help you out.
I was the one that was here last Friday, so I understand, Judge.
Yeah,
Well, I couldn't do math about 2 minutes ago, so I can't talk.
You sending Ellen?
I did.
Okay.
Yeah.
Mr. Ramsey, I'll call your case back up in just a moment. Let me do somebody else, do some other cases, and then we'll do that. Is it closed caption on?
The closed caption is on. I was told she can see it. And I think she's down there reading.
Okay.
Oh, she's unmuted now.
Okay, you're unmuted. Ms. Ramsey, can you hear me?
Yes.
All right. Okay. Where are we on this case? Counsel, you're muted.
Woo, good thing I'm in person at 3:30. This is a health hazard, Your Honor, for excessive clutter, hoarding, fire hazard.
Now we're in a completely different type of case. This isn't about money. This is about property condition and safety. The issue here is hoarding and excessive clutter creating a fire hazard. And legally, this falls under health and safety violations, which can justify eviction even without unpaid rent. What makes this complex is that the tenant isn't denying the condition. She's explaining it. She's describing physical limitations, ongoing efforts, and attempts to resolve the issue. So now the judge has to balance two things: the tenant's circumstances versus the safety risk. And in cases like this, courts often choose a middle ground, giving time to correct the issue while maintaining pressure to ensure compliance. This is no longer about finances. It's about whether the property is safe to live in.
And this is the first time we're before you. So last week we were before the magistrate. I do remember Ms. Ramsey mentioning something about an attorney. I'm not sure if that was, I got an attorney. I'm looking to get an attorney because there was some technical difficulties as well last time.
Ms. Ramsey, did you speak to legal services?
I did. They came and they looked at my apartment and they said that they're not going to represent me because this is not a serious case and that they had other people that needed them more. So that's it. I'm here by myself.
Okay.
I also have my manager here, Judge. I'm confused by that, but
Okay, and is it clutter or what are we?
Judge, I have Miss Johnson online. I would like her to maybe unmute. I have a bunch of pictures as well. Judge, it is a lot of clutter, but I think it became a fire hazard, and I think that's the dilemma. Miss Johnson, can you unmute?
Can you hear me?
Yes.
Yes, I can hear you now.
Ms. Johnson, am I describing the situation correctly, Or do you have anything else you want to tell the judge?
Yeah, I mean, that's basically it. I went and inspected the apartment yesterday and you just cannot move around. She said there were some things that were going to be removed to, like last night.
At this point, the case becomes very clear from a legal standpoint. When an inspector or property manager testifies that movement inside the unit is restricted, that signals a serious habitability and safety issue. This is no longer about clutter being inconvenient, it's about it being dangerous. Limited movement inside a property increases fire risk, blocks exits, and creates hazards for emergency responders. And courts take that extremely seriously. Now, the tenant is trying to frame this as a temporary situation, something in progress, something being actively handled. But the testimony from the inspection suggests otherwise. It indicates a condition that has reached a threshold where intervention is necessary. Here's the legal tension. The court must decide whether this is a fixable short-term issue or an ongoing violation that threatens safety. And in cases like this, judges often give one last opportunity, but under strict expectations. Because if the condition doesn't improve quickly, the court's responsibility shifts from patience to protection.
After the office closed and after I was there and saw it probably about 3 o'clock, and that she was still working on it. But it's just, there's so much that it's just really difficult. You can't even move around in the apartment very much.
Miss Ramsey, are you
Yeah.
going to get someone to help you move the things?
I had a statement from my practitioner who explained that the problem was that I had been having back spasms and that slowed me down. And I do have my niece. My niece came last night and we took some things out. The only things that are sitting around are, as I explained to Miss Johnson, is that I was clearing things out, going through cupboards and so on. And so I boxed things up to sort. And that's what's sitting there, is things to sort and get rid of. And
All right.
but the health issue has impeded that. So that's basically it. And it's not that I'm unwilling or that I don't know what I'm doing or what I want to do. I have a program, an agenda. It's just that my physical circumstances have slowed it down. So that's the state I'm at now. It's simply a matter of having enough time to finish the process.
This is the defendant's strongest argument, linking the condition of the property to a medical limitation, and legally, that introduces a different dimension. Courts are required to consider reasonable circumstances, including health issues. But here's the limitation. Explanation does not eliminate responsibility. Even if the cause is understandable, the condition itself still has to be corrected. She's presenting herself as organized, methodical, even helpful to others in the building. That's an attempt to establish credibility and show that this situation is not due to negligence, but due to temporary hardship. However, the court's focus remains on the present condition. Is the property safe right now? That's the only question that ultimately matters. So while her explanation may earn sympathy, it doesn't resolve the legal issue. The hazard still exists, and it still needs to be addressed within a specific time frame.
I have done this for other people in the building, several other people. I go in and I assess and I organize and I set up 3 categories, one for throw away, one for donate, and one for keep. And the keep is usually a plastic bin, so there's no cardboard or paper left around. And I also, for the last 4 years, I have been looking after 3 of my neighbors, trying to help them to be able to stay in their apartments. One of whom, there were gnats flying around in the hall, and he happened to say something about gnats coming out of his kitchen sink drain. So I went and bought all the supplies, and I came with my rubber gloves and my spray on Clorox gel that sticks to things. And I scrubbed out his garbage disposal to end the gnat problem.
Okay, all right. So Miss Ramsey,
Yes,
within the next week, you said you had packed a number of things in boxes, right?
well, I lumped them in the box, and those are things that
Okay.
have to be determined where they go and what happens.
All right.
to them. And
So
that's
can
it.
those things that you packed in a box, can you get them out within the next week?
I would think so.
You think you can?
Beg pardon?
You think that you can do that?
In a week, I can, yes, I can do some of that. I can get rid of the boxes.
Okay. So let's do this. I'm gonna end things in boxes to be removed.
Uh-huh.
And then what I'm gonna do is I'll adjourn this matter to July 7th, 2023 at 9 a.m.
And here's the judge's decision. A short adjournment. This is a controlled extension, not a resolution. What the court is doing here is giving the tenant a strict, time-limited opportunity to fix the issue. This is not open-ended. It's a clear deadline with an implied consequence. If the condition isn't corrected, enforcement will follow. Adjournments like this are strategic. They allow the court to avoid immediate eviction while still maintaining pressure. But make no mistake, this is not leniency without limits. It's a final test. The judge is essentially saying, you've explained your situation, now prove that you can resolve it. And in cases involving safety hazards, follow-up hearings often result in decisive action if conditions haven't improved. So this moment is critical. But it's not a win. It's a temporary pause before a final outcome.
Okay?
Okay, yes.
Thank you, Judge.
I have pictures on my phone of my kitchen, my pantry, my storage closet with all my cleaning supplies, which will show you how I organize and how organized I am. The only
Okay.
thing hindering me, as I said, was a physical impairment.
I understand. All right. Let's see what we can get done in a week, okay, ma'am?
Okay, thank you.
Th-
I appreciate it. And
Thank
Ms.
you.
Johnson also, thank you.
S&C Holdings LLC versus James Smith Jr.
Morning, Your Honor. Tracy Thomas appearing on behalf of the plaintiff. Mr. Smith, you're on
Mr.
mute.
Smith?
There you go.
Okay.
Yes, I'm here, Your Honor.
All right. And this is a termination case?
It is, Your Honor.
All right. And
Your Honor, there's not, last time we were in front of the magistrate, Mr. Smith indicated that he was making arrangements to move out. He's been on a month-to-month since May of 2019.
Mr. Smith, where are you on moving out?
Your Honor, I can't really do anything until tomorrow till I get my VA check. And then as far as renting a truck, and it's just me moving. I'm trying to ask for 10 days to get all this stuff out. I'm not, I don't have any help to move this stuff out. So,
All right.
Now we shift again, this time to a termination case involving a tenant trying to move out. The defendant is asking for time, not to stay, but to leave. That's an important distinction. When tenants acknowledge the situation and request time to vacate, courts are often more cooperative. But here's the issue. He has no immediate resources. He's waiting for a check, needs to rent a truck, and has no help moving. From a legal standpoint, that introduces uncertainty. The court needs to know whether the timeline requested is realistic. This is where judges balance practicality with enforcement. They don't want to force immediate eviction if a short delay could resolve the situation peacefully, but they also don't want indefinite delays. So the question becomes, is this a credible exit plan or just another delay?
Say you're a veteran? What branch?
Army, sir.
There might be some services through the VA that can help you a little bit. Counsel, what I'm gonna do is, so do you think you could be out in 10 days, correct?
Yes, sir.
All right, so rather than put a judgment against him, counsel, I'm gonna adjourn this out a week. Let's see if he can get most of his stuff out and move someplace and get himself on his way. All right.
Your Honor, as a suggestion, maybe adjourn it 2 weeks.
Yeah, okay, that's fine. As long as there's no objection.
And
All right, sir.
if we get word that he's out, then neither one of us need to appear in 2 weeks.
That's good. Okay, you got that, sir?
So you're adjourning it 2 weeks from today? Is that what
Yes,
you're
to the 14th, July 14th,
saying? Okay.
9 at 9 a.m. And that'll give you your 10 days and a little bit more to get yourself out, okay? And as Mr. Thomas indicates, if everybody's moved out and they verified it, then you guys may not even have to be here next week. Or 2 weeks out.
Okay,
Got it?
sir. Yes, sir.
All right. Thank you.
Judge.
Thanks.
Gene Pelliccio Living Trust versus Casey Adkins.
Morning, Your Honor. Attorney Andrew Babnick on behalf of the trust.
Casey Adkins. There's no one here. This is termination.
It
Do you
is,
wish
Your
to
Honor.
proceed, counsel?
I do, Your Honor. We were here last week in front of the magistrate, at which time Ms. Atkins had said she was going to be speaking with legal aid. This is a termination case, forceful or peaceful possession with forceful retention. She is the daughter of the decedent. The decedent died back in January. The property is already in the trust. Trust certificate's been recorded with Washtenaw County. We've given her plenty of time here. There was a notice to quit that was served back on February 16th. We waited to file the eviction to give plenty of time here. So what we are asking the court at this point for the entry of the default, and if the court would entertain the issuance of the writ pursuant to 600.5744 subsection 3, an immediate issue of the writ.
Now we move into a default judgment scenario, and this is one of the most one-sided outcomes in court. A default occurs when the defendant fails to appear or respond properly. And when that happens, the court typically grants judgment to the plaintiff with minimal resistance. Here, the attorney lays out the timeline: notice served, time given, no compliance. That creates a clean path for judgment. And importantly, this case involves possession without a redemption amount. That means there's no financial option to reverse the outcome. Once the writ is issued, the process moves forward without a payment-based escape. This is the consequence of inaction. When a party doesn't engage with the legal process, they lose the opportunity to defend themselves.
As we've pled that this is a result of forcible entry or peaceable entry held by force.
I think what I'll do, and counsel, raise your right hand, please. Do you swear or affirm everything that you said is true to the best of knowledge, information, and belief?
I do.
All right. What I will do is I will grant a judgment to the plaintiff for possession, no redemption amount. However, the writ will issue in 10 days. I'm gonna do it that way.
Understood, Your Honor. I'll prepare that. Your Honor, can those orders be submitted to your office via email?
Now, you need to submit them to the clerk's office, please.
Clerk's office. All right, understood. Thank you, Your Honor. Appreciate the time.
Thank you. Court calls the case of Patrick Durabi versus Carlton Barber.
Hold on, there you go. Hello.
Hello,
Okay, I'm sorry. I'm
Hello.
Talk to the.
I'm Patrick Durabi.
Says the paper proof of service. Yeah, I'm here. I'm so sorry. Now I'm big.
Last week, I was in front of the magistrate and he wanted proof of service. And he said that I could show it.
I need a copy in the court file.
I tell him it's a proof of service.
Yeah, it's a proof of service. They show me. Yeah. Okay.
All right, sir, here's what I'm gonna do. You need to get a copy of that down to the court. The
Okay.
proof of service. It has to be filed. So I'll adjourn it out to the 7th, 9 a.m. And I'll indicate we need a proof of service in file.
You had to get it to the court.
Oh, I gotta bring it to the court? Hold on 1 second. Yeah, I did that already. I brought it to the court, so I gotta bring it back to the court again?
You brought it to the court?
Yes, I did. So I had to bring it
When?
back to the court. That was May 25th. May 25th. This is it right here.
Ma'am, I don't have the proof of service in my file.
Okay, so what do I need to do now?
Okay, you need to get a copy of that proof of service down to the court so they can put it in the file. I'm giving you a week to do that, and then we can proceed on this matter.
Okay, so where do we go from here? How much longer, how long would it take before this case is taken care of?
Okay, I've adjourned it out 1 week
Yes.
to the 7th at 9 a.m. I need the proof of service before I can do anything, and I don't have a copy of my file.
Before you make a judgment, okay.
Yes, ma'am.
This case highlights a procedural requirement that often gets overlooked: proof of service. Before a court can make a judgment, it must confirm that the other party was properly notified. Without that, the entire process lacks legal foundation. The plaintiff believes they already submitted it, but the court doesn't have it on file. And in legal proceedings, if it's not in the file, it doesn't exist. So the judge adjourns the case, not because of the merits, but because of missing documentation. This shows how critical procedure is. Even if your case is strong, failing to meet filing requirements can delay everything.
Okay.
All right. Thank you. We'll see you next week.
Thank you so very much. Okay, I'm there.
Lawrence Caro versus Patrick Cox. And Laura Cox.
Lawrence Carroll here.
Got either one.
Patrick and Laura Cox are here.
Yeah.
Okay.
We're here.
All right, this is a termination case. And where
Yes,
are
sir.
we on this?
Your Honor, I implore the court's wisdom of Solomon on this one. It's a really tough case. I will tell you up front that Laura has paid all of the payments. There is not a financial deficit except for the assessment for cleanup that the township put on it last year, but I had made arrangements with Laura to make those in equal monthly installments, and she is making those. However, since the last time the township went out to that property and cleaned it up and assessed my taxes, they put it on my tax bill, and I had to pay $15,000. And my escrow has increased my mortgage payment by $2,500 for the past assessment that the township put on as taxes, which was allowable by the court order. And they're anticipating that it's a tax, what's going to happen again. And I'm just losing my shirt right now on this. We went to court again on Tuesday, and another order was issued by 14A4 allowing the township to go back in and clean the property up because they gave them, and that was filed in February, and it's still not cleaned up. And she finally just said, township, go clean it up and assess the.
Now, this is a different kind of dispute. Financial pressure on the landlord due to property condition issues. The plaintiff is explaining that cleanup costs are being added to his taxes, increasing his mortgage payments. That creates a chain reaction of financial burden. What makes this complex is that the tenants are responsible for maintaining the property, but the financial consequences are falling on the landlord. So the court has to determine how to allocate responsibility, and the judge's approach is clear. If the tenants fail to clean the property, they may be held financially accountable for the resulting costs. This introduces the possibility of monetary damages, not just possession.
Assess the Coxes. Unfortunately, the order that the township has proposed to that judge would allow them once again to put that assessment on my taxes, which means I'm going to end up paying it, not the Coxes. So I'm imploring your words of wisdom. I can't get them to clean it up. The township can't get them to clean it up. The court can't get them to clean it up.
Mr. Cox, what do you want to say?
Yeah, this is Patrick Cox. What Larry's saying is largely true. But the reality is that we don't ever get it cleaned all the way up. So I think that I just want to say that, and meaning that it's not something that I'm just ignoring. It's something that I have struggled to get done within the time that was allotted, and I believed I had enough time, and I was just wrong. So the property is in much better shape than it was. I mean, to some people, they may say that it's not, but it's just not. It's just not seeing the property the way that I see it, because I walk it, and so the majority of what was nearer the street remains. And so I think that it just kind of casts an ugly look over the rest of the place. But having said that,
so
the
how long
truth
did
is
Judge
that
Freshour, how long did Judge Freshour give till the township's going to come in and clean it up?
She did not
essentially
give us-
immediately, but the township, I'm sorry, Larry, I didn't mean to cut you off, but just that I don't think she put an actual time on it, Your Honor. I think she just said they have the authority to do that. And I did ask in court with the prosecutor how long that might be before they came, because I'm fully committed to them not
And
coming.
what did they tell you?
He said it might be, he said it'd probably be about 2 weeks, because his the guy from the township is on vacation, so he won't even be back, and then attempt to schedule it for
Your
I don't
Honor?
know the exact amount of time, but he thought it'd be 2 weeks.
Your Honor.
Yes, sir.
I did speak with Mr. Toth, who's the zoning administrator for York Township, and he did tell me that he has a July 10th date tentatively scheduled. Again, I have a motion before the court. I don't even know if I have standing, but I have a motion that I submitted before the court asking the court to prohibit the township from assessing my taxes and find a way to collect from the Coxes. I don't know if that will be successful. I don't know if I have standing, but if this is allowed to continue, I will lose that house.
All right, but that motion is not before me, is it?
No, it's before Judge Anna
Freshour.
Freshour, because she's the
Yes.
one that made the ruling, and she's the one that's going to approve the
Right.
language.
So when is that motion set?
It's not said. I haven't heard anything from her. Again, I don't even know if I have standing.
Okay, I don't. Got it. Okay. So here's
And
what
Your
I
Honor-
here's what I'm gonna do. You realize you've got 10 days to do that, but the thing that I'm also gonna do in this case is I'm gonna allow the plaintiff to amend the complaint to request damages. It's another thing in terms of getting paid. So what you'll have to do, sir, is you'll have to pay the difference in the filing fee for the damages
Okay.
portion of it, okay? And then I'm going to adjourn this out to the 14th. If it's not cleaned up and the township has done it, if you have a township bill, then I'm going to allow those as damages against the Cox in this matter.
Okay. I'm not sure I entirely understand that, but
okay, so here's the
agree
bottom
with it.
line to it. You guys are supposed to clean that property up. The property has to be cleaned up. The township, Judge Freshour has ordered that the township do it if you guys don't do it.
Correct.
And plaintiff in this case is saying, well, if the township comes in and does it, then I owe the money and you guys are supposed to pay it back when you're the ones that are supposed to be keeping it clean. So what I'm
Right.
saying is if you guys don't get the property cleaned up, I'm going to give a judgment, a monetary judgment, not only for the property, but a monetary judgment to the plaintiff for whatever the costs are in cleaning it up.
I understand. All right. That's more than fair.
Would
Okay.
this court entertain a motion prohibiting the township from assessing my taxes?
That is not my case. You'll have to bring that before Judge Freshour.
Appreciate it, Your Honor.
All righty. July 14th, 9 a.m. Thank you.
Thank you.
That
Thank you.
ends our 9 o'clock block. We'll get ourselves set up for the 10 o'clock court is standing.
This final moment ties everything together. Across multiple cases, the same pattern repeats. Obligations unmet, timelines missed, and courts stepping in to enforce outcomes. In this specific case, the judge is making it clear that failure to act will result in financial consequences. Not just eviction, but monetary judgment for damages caused. That's a critical takeaway. These cases aren't just about losing a place to live. They can result in long-term financial liability. And looking at the broader picture, every case we've seen follows the same principle. The court provides opportunity, but expects results. Whether it's unpaid rent, unsafe conditions, or procedural failures, the outcome always depends on compliance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.